The art of negotiation. My office deals in litigated matters in the areas of surrogate court practice, divorce practice, and matrimonial practice. It's myself and an associate. And what we do is we plan for a hearing. We plan for litigation. If we are properly prepared, then we can settle. It makes sense. You have to load the gun before you can fire. So we do our due diligence. We do our discovery. We make sure that we're prepared. We prepare with our clients for testimony, witness statements, things like that. Also, it makes sense. And I love to settle. I love to arbitrate, mediate. I've been trained as a mediator. It's in my DNA to settle cases. I don't like conflict, really. So it's in my DNA. I want to settle. I want to settle fairly. I want to arrive at an agreement that's acceptable to my client. So if there's $1 million and we're supposed to split 50-50, right? My client should get $500,000 if that's the example. But sometimes there are reasons for your client not to receive that money, right? I don't know in this example, but perhaps we should ask for a larger amount based on our own unique circumstances and specific factual circumstances. If you start with the number that you want, that you're entitled to, often you'll get less. Why would you get less? Why does that make sense? Well, in order for us to get $500,000 in my example, they may need to spend $65,000 in legal fees. And over a length of time, that will take an emotional toll. So we can get the appropriate amount of money, the legitimate amount of money, the factually fair amount, but it costs our client money. It will cost the other side money too. So this is where you play the game of chicken, and it might be that the other side will resolve the issue earlier. But whenever appropriate, whenever we can, if my client was entitled to $500,000, maybe we take $480. Again, I'm just making up numbers, but maybe we take up $480. We take $480 instead, so that we save our client the $65,000 in legal fees, the $55,000 legal fees, whatever it might be. That's a reasoned, prudent approach. Does it make sense in all cases? No, it doesn't. And sometimes you have to fight. Sometimes you have to ask for more so that you can. It also helps to ask for a lot of things, right? So early on in the process, you don't want to say, I'll waive your pension, I'll waive your annuity, I'll waive this. I'm not interested in the house. I don't need that. I don't need maintenance. No. You leave everything on the table. The law provides for a number of remedies, options, depending on the case. So don't early on say, I'm not interested in the house, because once you take that off the table, it limits your ability to negotiate. It's extremely difficult to negotiate with an unreasonable person. So perhaps you have to keep some unreasonableness in the beginning. I want the house and the rental property and the stocks and bonds and a percentage of your mother's house and the money you had from before the marriage because it grew during the marriage, whatever it might be. I'm not saying throw out crazy things, but don't give up early on what you are actually entitled to. Otherwise, the unreasonable person wins.